The hijab debate, which is happening currently in the Supreme Court, took a major and dramatic turn today. The Solicitor General claimed in court that this entire thing was a conspiracy by the Popular Front of India. He insisted that no girl students were wearing the hijab or insisted on wearing the hijab until late 2021. That's when the campus front got involved in this. There was also a reference to what's been happening in Iran over the last few days, where women are coming out openly and rejecting the hijab. If this can happen in a theocratic country like Iran, why cannot it happen in democratic India? But first, the story so far. All right, the big hijab debate tonight here on Brass Tacks. Here in our studios, I'm joined by Firoz Ahmed. He's the former Chancellor of the Maulana Azad National Urdu University. S. Prakash, spokesperson of the Karnataka BJP, on the broadcast this evening. Maulana Ali Qadri, Islamic scholar, also on the broadcast. Shatabish Shivanna is advocate representing the hijab petitioners. Atikur Rahman, Islamic scholar, and Zakia Soman, women's rights activist, joining us. Mr. Firoz Ahmed, let me start with you. The Karnataka High Court had in this matter very clearly in its order ruled that wearing the hijab is not part of essential practice. So the petitioners going to the Supreme Court in challenge of that decision, when the court has already ruled that it's not an essential religious practice and therefore it is not mandatory that hijab needs to be worn inside an institution, whether it's a college or a school.
All right, Zaka, I think we have to rise above this element of this thing being the essential part of Islamic tenet or not, because there are 5 essential tenets of Islam like namaz, roza, zakat, hajj, all these things. Main thing is, we are studying in a school or college. The school or college says this is our dress code, or this is a writing code. All the students, they should use the blue ink for writing their exam papers or their assignments. They should not write with blue or green or something like that. So one has to follow that. The country, especially a country like India, it is not run by Sharia, right? We are not concerned about Iran. Even if Iran is run by Sharia, the way they took the life of Masha, that was horrendous, heinous, horrible, horrific, and above all, inhuman and devilish.
Okay.
I went down with the moral police regiment of Iran. And finally, having said that, Zaka, I would also add that the kind of debate which is going on in the court in favor of hijab, let me tell you, hijab has nothing to do with the education of the girls. The girls should actually say that we do not want hijab, we want class, and down with the slogan, no hijab, no kitab.
No, I also the Solicitor General Atikur Rahman today expressly saying that this entire thing came to the fore, that a few girl children in a couple of colleges in coastal Karnataka, they only insisted on wearing hijab from late 2021 onwards. And the Solicitor General's contention was, this is the Karnataka government's contention, that this was after the involvement of the Popular Front of India. So this was done for political reasons, perhaps even for nefarious reasons, but not something that the girls wanted to or insisted on. Certainly they didn't before late 2021. Atikur Rahman.
Well, Zaka, if the Solicitor General is very much true that the campus front of India is involved in this thing, we should be very much satisfied then that such radical elements, if these organizations are, only 6 girls are, towing the line of this organization out of 90 girls. If it has 96. Been a religious compulsion, all 90 girls would have demanded a hijab, but out of 90 girls, only 6 went to the court, and that too they went to the court just to tell the court that constitutionally or even religiously they should be granted this concession about the uniform, along with the color of the uniform, is the state of India not that large enough to grant the girls to educate themselves with this minor, this thing in the uniform?
Sir, if I can make an intervention, sir, if I can make an intervention, you say, isn't the state big enough to make this concession? It's not a question of a concession or not. First of all, the argument taken by the petitioners was that this was part of a fundamental right. So a concession can never be a fundamental right. A fundamental right is a fundamental right. You and I and Mr. Firoz Ahmed, everybody on this panel is entitled to it. Yeah, that is one part. So it's not a concession. Secondly, the most important part is, how does the state then say, okay, we'll make a concession to one section, but we can't make a concession to another section? That is discriminatory practice. The law has to be applied equally. And if the law is that there is a uniform, and if the law is, and as per the judgment of the Karnataka High Court, this is not an essential religious practice, it has failed the ERP test, then everybody should follow that. That's why we have courts of law in this country.
Agreed, Zakka, agreed. Then what about the law, the Education Act of Karnataka, which says that no rule should be made irrespective of, any of the religious arguments in it. If a student is barred on this particular aspect, that no, if your religion does not, essentially provides you for this, you cannot have it. Is this not a hindrance on the part of the students entering a education institution? This was the contention of the petitioners, lawyers in the court.
No, Shatabi Shivanna is also on the broadcast. He was one of the lawyers for the petitioner in the Karnataka High Court. Again, Mr. Shivanna, you can't have it both ways. Either the contention or the argument taken is it's an essential religious practice, therefore it should be allowed, which argument failed in the Karnataka High Court. Now you are bringing in the freedom of choice argument. The freedom of choice argument does not hold forth, and again there are multiple High Court rulings on this. Once you enter the four walls of an institution where there are uniform rules for X, Y or Z, if you are a student, these rules apply to you, whether you are Muslim or Hindu or Christian is irrespective. Mr. Shivanna.
See, it was our argument that the state passed a government order restricting Muslim girls from wearing a hijab. Now, the burden is on the state to prove that why is this restriction in place. Our contention is it's in violation of Article 19. Now, we have established our right, whether it's essential religious practice or not, we'll get into that later. Now, when there is a right, we have established our right, and the government imposes a restriction on it, it is the burden of proof shifts on the government to establish as to why this restriction is being imposed. Is it against public morality? Is it against public order? These questions were posed to the government order. Our first and primary argument and submission before the Honorable High Court of Karnataka was that the government order is unsubstantiated in law because they cannot impose such a restriction on these Muslim girls.